session. God save the United States, the state of Tennessee, and this honorable court. Be seated.
Good morning. I'm glad to have you all here. Reminder, the oral arguments are streamed live on YouTube, so it'll go out as you're doing it, and then will be posted later on the court's on the YouTube site. Call the first case, please.
Shay, Lynn, Starnes versus Olukayode, Akinlaja.
We'll hear from the appellant.
Thank you. Good morning. My name is Ben Miller. I represent the appellant Shay Starnes, and I would like to reserve 3 minutes of my time for rebuttal, please.
That'll be fine.
Thank you. First, let me say thank you too for accommodating my request to reschedule due to my scheduling conflict. I know we're the only case on the docket this morning, so I'm going to do my best to get the court out of here as soon as possible. Fortunately for me, I think it's easy to do for me to be brief because the issue for the court to decide is actually quite narrow. Can facts and opinions acquired by testifying experts in preparation for litigation be discovered through document requests, whether that's through requests for production, subpoenas, notices of deposition that include requests? And the answer quite simply and plainly is no, because of Rule 26.024, which opens discovery of facts known and opinions held by experts otherwise discoverable under the provisions of subdivision 1 of this rule and acquired or developed in anticipation of litigation or for trial may be obtained only, keyword only, as follows: interrogatories, depositions. So I think it's also important to distinguish what the issue is not. The issue before the court is not whether this same rule prohibits document requests altogether. For example, for things like invoices that an expert has generated, or the expert's curriculum vitae. Those types of things might go to a witness's bias or qualifications, and that is not what we're talking about today. But just like 26.023 is a rule that protects against trial preparations, it's in the name of the rule, in the name of the subsection. That same language, trial preparation, is also in Rule 26.024. And if the court were to rule, as the trial court did, that opinions developed by experts are discoverable through things like emails, notes, draft reports, the word only would become meaningless. And this rule would have no protection whatsoever. It is a trial preparation protection rule. And instead of acknowledging that and trying to address that, the appellees, the defendants, instead turn to and say, well, discovery is very important. Discovery is about truth-seeking. It's about making sure that we uncover the facts and we're not surprised at trial. But let's call it what it really is. It's about trying to find impeachment material. That's what they want to find in an expert's handwritten notes, in draft reports that may not be the final version, but that's true of all work product. Work product is always going to have the potential for some great impeachment material. You better believe the parties themselves would love to get a hold of each other's notes that they've made in preparation for litigation or for trial. But that's what work product is. And the desire to try to discover impeachment material does not trump the work product doctrine and the protections that we have in place.
Let me just ask you this as a practical matter. I'm trying to think back to when I was practicing, and I know we always got expert reports before we took expert depositions. Like usually the expert would prepare a report with a summary of his or her opinions and the bases for that, and we got that. And I can't remember how we got that, but according to you, we shouldn't have gotten that?
Well, Your Honor, it probably depended on what the nature of your practice was, and because in federal court, it is a requirement that an expert provide a signed report. Tennessee does not have a similar rule. Tennessee's rule is this 26.024, which instead of requiring a report, puts the burden on the party to identify very similar things that are laid out in the first section, A1. In an interrogatories, you have to lay out the same types of things that you would expect to find in a report in federal court. So there is a big distinction there where, our experts in Tennessee are not required to sign off on what the party submits, whereas in federal court they are. So there is a big distinction there, and you're right. Even in federal court now, those drafts of the reports are not discoverable explicitly. And one of the issues that's been raised and argued is whether or not Tennessee, why they didn't change their rule to explicitly follow that if that was their intention. The explanation I would offer is that we didn't need to. It was already there. We already had this rule that very specifically limited the types of information that you can get from an expert. It's very explicit that all you're going to get are these things we've identified in interrogatories when it comes to facts and opinions, and that's, again, very, very important. We're not talking about the overall breadth of discovery, which is what the Lassiter case has been brought up for, to show that the Lassiter case held, in certain circumstances, it might be appropriate to subpoena a testifying expert for their financial information to show how much of their income comes from testifying work. But has nothing to do with the facts or opinions that they developed in preparation for this case. So it takes it outside of 26.024.
Can the opposing counsel require your expert or you require their expert to furnish, here's the medical records I looked at?
Yes, sir. I think so.
How? Under what? Under your argument, aren't those documents?
Well, I don't think that they would constitute the opinions that the expert has formed. What we're talking about is, can the expert be required to divulge documents that are going to contain their opinions? So to make it more specific and concrete.
Well, it may not be their opinions because they're talking about communications from you to the expert. That wouldn't be the expert's opinions, would it?
Well, in this particular case, that's exactly what we're talking about. The email that is at issue that sort of brought all this to a head was an email from the expert to me, bullet pointing his opinions. So that is what we're talking about. We're talking, and I think that the court will also see that the appellant has not taken the position here that all communication falls within under this rule. Again, it's limited to documents that contain the opinions of the expert, because the record in this case will show that the appellant voluntarily did turn over communication between the expert and myself, because it was an email from me to the expert, basically inquiring as to his availability, giving a brief synopsis of the case, didn't contain any of my mental impressions, which again I would have objected to if they did. So this is not about are all communications prohibited, it's about are documents, including communications, prohibited if it contains the opinions that this expert is developing in preparation for this case. I want to talk very quickly about waiver because a great deal of time was spent in the appellee's briefs on that. But I would first, before I talk about it substantively, I would first point out to the court that it was never explicitly argued in the trial court. And it does not appear in the trial court's order. It did not serve as a basis for the trial court's order. So I would suggest to the court that it should not be considered for the first time on appeal. However, if the court is inclined to do so, there are essentially two grounds, as I read them, for why the appellees have argued that the appellant has waived any protection of these materials at this point. The first one is the lack of a privilege log. But the privilege log presupposes a duty to that those documents have come due and that it is time to produce them, and they're being withheld currently because of this assertion of the privilege. But it has not been shown that these documents were ever properly came due for a couple of reasons. Number one, it has been argued that the appellant should have produced these for in-camera review to the trial court pursuant to the order that's here on appeal. The trial court's order said if there are any attorney mental impressions that are objected to, those can be submitted. I would submit to the court there was no deadline in that order. That order is what is on here on appeal. It did not come time for us to comply with that order. We had a right to have it appealed to this court first before we had to comply with that. Second, there was a notice of deposition that was served for the expert's deposition. In that in that notice, there was a request for production of these documents. The rules are explicit that requests for production that are contained in notices of deposition are for party deponents. It is when you are deposing a party, you can take advantage of Rule 34 for a request for production. The expert in this case, Dr. Anderson, is not a party deponent. Including request for production in his notice of deposition was not an appropriate way to do that. If you want to request a non-party deponent to bring documents to a deposition, the appropriate way to do that is through a subpoena. It puts everybody on notice that the subpoena has been issued and that there's an opportunity for an objection at that time. The third and final way was the original request for production that were served way back when the case got started, as the parties typically do. Plaintiff did it, defendants did it. They asked for all the stuff that we know that eventually is going to come out. The answer to the request for production at the time it was answered was, we have made no decisions about testifying experts at this point. And that's a very standard response. So there was no documents were withheld when those responses were originally made. And neither of the defendants has cited any authority for the proposition that this is one of those things that is contemplated by the rules that has to proactively be supplemented. The rules are very explicit also about what does need to be supplemented. The identity and the opinions of an expert does, but this type of thing doesn't. And in fact, I think it's telling that scheduling orders recognize in just about every case what is required to be supplemented, which is why we get a scheduling order that says when the plaintiff is going to identify experts, when the defendant is going to identify experts. Those are things that must be supplemented, and they show up in a scheduling order. I don't think it's the doctrine of unclean hands, but maybe the doctrine of you can't sit on your hands. The rules also provide a mechanism for any party to affirmatively request supplementation. It would have been very easy for the defendants. They knew that response from years ago that said that no decisions had been made regarding experts yet was no longer current. They knew that we had not supplemented it. It would have been very easy for them to issue a request pursuant to the rules that said, we would appreciate we're getting ready to take these depositions. You answered this the way you did years ago. Now you've obviously disclosed your experts. We would appreciate you supplementing your response to those requests for production that requested these various things. We could have done it that way. We could have responded, supplemented our answer that way. I'm out of time. Unless the court has any additional questions for me, I will sit down.
You have your time for rebuttal.
Thank you.
Thank you. We'll hear from the appellee.
Good morning. May it please the court. I'm Josh Walker, representing the state of Tennessee. I'm going to talk about 3 issues as we've broken it up on this side, and Mr. Powers are going to talk about the next 3.
All right, so how much time do you want then?
I think we're going to try to do 50-50, so I guess that gives me 7.5 minutes. And I'm thankful you're going to put it on the calendar because then I have to, or the clock, because then I have to do no math.
I always appreciated it.
Yes, that's good for me. I guess,
yeah,
there it goes.
She'll start it. You can go ahead.
Okay. The first issue I want to talk about is well, first off, I should say, is I see the claimant's argument. They basically have 2 issues. Number one, the materials that are at issue in the trial court's order aren't discoverable anyway under 2602A4. And then the second issue is, does work product protect these things, I guess, if they are discoverable? So I want to talk about that first issue first. And I would submit to the court that these materials are discoverable. And the reason the Lassiter opinion matters, it's not so much what they were trying to get, but it's how they tried to get it. If you look at Lassiter, it started out, it was a request in a deposition notice, the same thing that's been criticized here, for the expert's financial information, for all income, for serving as an expert in all cases for a 10-year period prior to the date of that service. And as I said, it started with a deposition notice. That was not followed. There was discussion about issuing a subpoena. Then they got down to the point where they were going to produce the expert's accountant's affidavit giving this information. So now you've gone out beyond the expert to someone employed by the expert. And eventually that information was not produced and that expert was excluded. This court affirmed that exclusion in the Laster opinion, and part of the argument that the plaintiff made there was these things aren't discoverable under 2604A1. It's limited to that. This court rejected that argument and said, however, the rule that we just talked about, 26.024A1, was not intended to establish an outer limit for what can be discovered about an expert. There is no indication on the face of the rule to suggest that a party is absolutely prohibited from seeking additional information about an opponent's expert witnesses, and we decline to interpret the rule in such a manner. And then the court went on, it was not unreasonable under the facts of this case to require the production of documentary evidence confirming Dr. Evans' previous estimate of his annual income.
Now, but the language used there, additional information about the expert witness.
Correct.
About the expert witness.
Well,
Which is what was asked for there, right?
Yes, and I think that's why it's two
And this
separate.
was the information you all were requesting, was it about the expert witness?
It's about what he's seen in this case and how it can affect his opinions, which I think that's a separate issue then, is that protected? But I think the first issue, is it even discoverable in the first place? And I think Lassiter stands for the proposition that 26.02A41 is not an outer limit on what you can get.
Well, it must mean something, though. I'm familiar with the language in Lassiter, but I mean, it provides, provides a mean for obtaining discovery from the expert, doesn't
Yes,
it?
and the court sets it up as that's a beginning floor to reduce costs. These are things that you just basically, upon request, have to produce, but you can get other information about an expert by using the other tools. The other
You think the language about the expert isn't limiting? I mean, anything related to what he saw?
I mean, I think it would be
What
limited.
lawyers told him? I mean,
It would be limited in the same extent that any discovery is limited by the broadened relevancy standard that applies to discovery in all civil cases in Tennessee. But here, we're talking about, if you look at Lassiter, I mean, this was nothing to do with the substance of his testimony. This was going to be pure impeachment. We're talking about the substance of his testimony, what may have affected his testimony. How was this case presented? What was he told? Those bullet points that he gave in his opinions, are the same things there? It may be identical to his disclosure, but the cases that we talk, and Lassiter talks a lot about this, we don't have to take the other side's word for that. We're entitled to see, and if there's a discrepancy, we're entitled to ask why. Why did this opinion disappear? Or why do you have this additional opinion that wasn't in your bullet points? That's all proper cross-examination of an expert, but you can only do that if you can get that information. I think if you look at the case.
Am I correct that you would agree that this goes both ways? The plaintiffs could get this information from the defense expert?
Oh, absolutely. It has to go both ways.
If your client, the physician, is going to testify that she complied with the acceptable standard of professional practice, is she testifying as an expert?
Client would be testifying as not as a retained expert. And I think that goes back to the dichotomy. I can't remember the case name, but you've got people who have expertise but gain their knowledge because they were actually involved. Then you've got people who were hired to review the case and then form opinions. And that's a Rule 26 point.
Her I'm sorry, I didn't mean to interrupt you.
No, that's fine.
But her testimony that I complied with the acceptable standard of care, is that not an expert opinion?
It is. It does not fall under Rule 26.024 because she wasn't retained to give.
So they can't. So the plaintiff can't get this information from one of your experts. Maybe your only expert.
Well, when you're talking about a client,
The same information you're requesting.
But a client raises a different privilege, an actual privilege. Work product is not a privilege. A client then raises the attorney-client privilege, which is a separate animal that's not at issue here because we're not dealing with a party giving this testimony.
It doesn't. I mean, it wouldn't cover your communications to the client necessarily, would it?
Only if you're correct. The statute gives attorney-client privilege protection only to what the client tells the attorney, unless what the attorney says would reveal or disclose a confidential communication.
You think just the fact that this expert is also a party shields the expert from having to disclose what every other expert has to disclose?
To be honest, Your Honor, I haven't thought about it that much because
Probably
in my
not,
position with the state,
Yeah,
the doctors, the state employees are not the parties. The state is the party. So it's a little bit different
I
situation.
understand. Maybe I'm asking the wrong lawyer. on that question.
So I apologize. I think that's about as good as I can do on that. But I do think it's
That's
different
fine.
for a party
That's
because
fine.
it raises that privilege. The other thing I want to get to before my time expires is the comparison to the federal rule. And I think that's very important. The federal rule in 2010 was amended to protect the very things that we're trying to get in this case and that the trial court ordered as were appropriate to discover. And if you look in the claimant's reply brief on page 18, they cite to you advisory commission comment on that. And it says the committee, and this is about why the amendment was made by the feds, the committee has been told repeatedly that routine discovery into attorney expert communications and draft reports has had undesirable results. So this was a routine practice and occurrence under the old federal rule, which the Tennessee rule was modeled after and still has the same substance. Now theirs is worded a little differently because they did a rewrite a while back, but the same material that you could get under the old version of the federal rule, you can still get under the Tennessee rule. And it was routine to get this material. Now the federal courts thought that was a problem. They changed their rule. Tennessee hasn't done that. And our Supreme Court told us in the Thomas v. Oldfield case that when the federal courts have made a change and Tennessee has not, they describe that as conspicuous, and we don't do the same things they do. This material was discoverable under the old federal rule. It was routine, and so it's still discoverable under our rule. My time's up.
Thank you.
Thank you.
Good morning, Your Honors. Josh Powers from Chattanooga with Baker Donaldson. And Judge Swinney, to address your question, I do represent Dr.
Yeah, I was asking the wrong lawyer.
Well, no worries. I do represent Dr. Akinlaja in this case. And I think here's the way I would approach your question there. Because what's at issue here was I'm taking the deposition of Dr. Anderson, the plaintiff's gastroenterology expert, and asked, did you have any other communication? Oh, yes, I did have this other communication where I sent an email to Mr. Miller's office with my bullet points of here are my opinions. If Dr. Akinlaja sent an email to me saying, hey, Josh, I have looked, I've gone back and looked at the medical records. It's been a couple years since this baby was delivered, and now I've looked at the medical records. Here are my opinions. That's classic attorney-client privilege, because that would be in a communication from Dr. Akinlaja to me that would be fully protected. And I think the way our litigation system is set up, he will be thoroughly questioned and cross-examined in his deposition about any opinion that he would tend to offer. And a lot of times in these cases, what we have is, like Dr. Akinlaja as an obstetrician, his opinion is going to be limited to the standard of care issue. Did I deviate from the standard of care? I'm not a gastroenterologist. I don't know if whatever, with this transection of the cecum, if that caused any ongoing gastroenterology issues. So I think it's just would be classic attorney-client privilege. So here, what I was wanted to talk about is, so first of all, I've been practicing for 30 years, and I've been doing med-mal defense work for 25 years. And the absolute custom and practice has been, with what the lawyers are out there doing in the state of Tennessee, are attaching a list of here are the documents that we want the Rule 26 expert to bring to the deposition, and that routinely includes communications. I just got through with a case, I'm sure the council knows C.J. Gideon, one of the finest lawyers in Tennessee. Mr. Gideon happened to have a plaintiff case. I was defending the case. I took 3 of his experts' depositions, and in all 3 of those depositions, without objection from Mr. Gideon, I questioned his experts on the communications between Mr. Gideon and plaintiffs and his Rule 26 expert. So I would ask the expert, so tell me what when you met, did you meet with Mr. Gideon? Yes. Tell me what you discussed, and without objection. So that's been the practical, and I think the reason is that certainly.
But is that different, though, than requesting copies of the communications? Because the rule specifically says you can get information through interrogatories and you can get information through depositions. So that would be in compliance with the plain language of the rule. His argument is, that's fine, ask away, but you can't get the actual physical documents because there's no request for production applicable.
Right. And so whether it's, whether you travel under Rule 34, there is nothing in subsection 4. It says, through interrogatories and depositions, there's not a preclusion to also use Rule 45, because if you think about it, I mean, how limited are you going to be in taking an expert, especially these, and I'm not, Dr. Anderson, I don't think Dr. Anderson would fall within this category, but, and these experts are on both sides. I'm not just saying it's a plaintiff side, but you have these professional expert witnesses. That's what they do for a living, is they testify. And whether it's an expert for the defense or whether it's an expert for the plaintiff, if we're hampered by not being able to have a full understanding, it's going to limit our ability to get to the truth. And that's, at the end of the day, that's what this is about, is getting to the truth. So, Your Honor, and I don't know if in this case, if we specifically designated Rule 45, but Rule 26 does not exclude or prohibit a Rule 45 subpoena.
What does it do? What's its purpose in saying, here are two methods you can use, interrogatories and discovery? Why didn't you say you can obtain through discovery?
Well, I think what it comes from, I think the prior iteration of the rule is that you couldn't take depositions. First, you couldn't take depositions of experts, and then I think the rule was changed to allow that you could petition the court. So, hey, Your Honor, we would like to take this deposition. So, I think you would have to go back into the in the history of how Rule 26 has been modified over time. But I think it was a way to tell. I don't think it was where it was a limit to say you can't do these other things that are absolutely attendant with virtually every deposition you take. I mean, going to take the deposition of an expert without documents. I mean, I think there was a question, Judge Davis, I think you asked about, or maybe it was Judge Swinney, about what about the CV? What about these other, because one of the things that Plaintiff's Counsel, did produce was an email from Mr. Miller's office to Dr. Anderson stating, Dr. Anderson, we want you to answer, we would like for you to give us an opinion that the defendants caused harm that would not have otherwise occurred. So we get that communication, we get the CV of the expert, we get invoices of the expert. Well, those are documents, and those are readily produced and not objected to. So if documents aren't included, why would they have to produce that information? Because because ultimately what you have is you've got the federal rule that is the federal rules have decided this stuff is not discoverable. And the way that the federal rule got there was a specific express amendment to the comparable Rule 26 that specifically says you can't do that, you can't get this. And I think the way the rule is crafted here, I think the emphasis on only would be too great of an emphasis. I think what it's saying is I can't send a Rule 34 request to the plaintiff, but if I'm taking that deposition, that I'm entitled to get documents that are related to that expert's opinions. And again, I'm saying my time is over, but
that's all right. You can finish your thought.
It's all, Your Honor. I think it's about getting to the truth, and what Mr. Walker indicated was this. We have a supplemental, the first disclosure was completely vanilla. It just said the defendant caused harm, literally, that's what it said. Then we get a subsequent supplemental disclosure that says, well, the plaintiff had this pre-existing irritable bowel syndrome, but it was asymptomatic and you now made it symptomatic. I want to see what the bullet points were in that email so that when I question Dr. Anderson, I can see, well, because remember what the whole purpose of this is for the jury to decide the issue on the facts, not on legal maneuvering. And so I think we're entitled to compare what was in his bullet point. We're not trying to get to Mr. Miller's mental impressions.
What if Mr. Miller sends him a letter or contacts the doctor and said, I need to know if I've got a lawsuit here. Here's the records. You review it and give me your opinion. May not be any lawsuit there. And he gets a letter back or email back with the bullet points showing that, yeah, the doctor thinks that it may be. Why is that not work product?
And I think because that's a consulting expert, and I think the rules are set up where you treat a consulting expert differently than you do a testifying expert.
Well, then he decides to use him to testify.
Well, then if he decides to use him and testify, then it's, I can tell, certainly represent to the court, historically, that's all been discoverable. That's why Judge Hollingsworth, ruled the way he did, because even at the hearing with Judge Hollingsworth, he said, because, he was a tort defense lawyer. He did products liability defense work. And he said, in my experience, this has always been discoverable. And
so the lawyers work to find out whether or not there's a potential lawsuit there. After he determines that there is a potential lawsuit there, the work that he did to determine that is, assuming he makes that expert, becomes the trial expert, then it's discoverable.
It can be, Your Honor. I don't know if we have additional facts to it, but remember, we're talking about an expert witness here. We're not talking about a party.
It becomes an expert witness.
If that person becomes a Rule 27, we're not talking about the plaintiff, his communications with the plaintiff or our communications with our clients. We're talking about communications with an outside actor who's getting paid handsomely. We're talking about these, especially get these neurosurgeon experts, they're charging $1,000 an hour. And so you're getting people, so you put that kind of money into the system. This is just a check and a balance that allows us, both sides, because it goes both ways. Because I'm certain we tell when we hire an expert, do not send us an email. Do not pick up the phone and call us.
I was about to say that if we go with you, I think the phone company will become back in demand again for actual telephone calls as opposed to emails or mail.
I would say, Your Honor, if we got all the lawyers that do this work to raise their hand, that is the way that it's done practically.
Okay,
Thank you for your time.
Yeah, we'll hear from the appellant rebuttal, and we'll give you a little extra time too.
Thank you, Your Honor. That's all right. I will be brief, and I think I just want to touch on the conversation that has been had. I think the point that both Judge Davis and Judge Swinney have made is the right one, which is if we ignore this language, only interrogatories, only depositions, what is the purpose of this rule? The defendants, the appellees, have not offered any explanation as to how this is a trial preparation protection rule at all. And again, it's in the title of the rule. It is trial preparation. The purpose of it is to limit what is otherwise the broad realm of discovery. So there has been no...
What about the Rule 45 argument that Mr. Powers made, which is we can depose him and we can obtain that deposition by subpoena under Rule 45, which allows us to ask that he provide documents, he or she?
The answer, I think, Your Honor, is that a general rule has to give way to a more specific rule. Rule 45 is a general rule for subpoena. You can subpoena anybody within the court's subpoena power. Experts, fact witnesses, whomever. But we can't just say that just because this one general rule that doesn't touch on experts at all of a sudden comes in and says, forget what we said in here about that limiting part of discovery of facts and opinions developed by experts, and that's the end around. Again, we'd be making the entire rule pointless.
Well, it doesn't really say, Rule 2604 doesn't really say only by interrogatories and only by depositions.
That's right. It says only as follows, and it lists interrogatories and it lists depositions. So I think it would be constrained reading to try to read request for production in there when they go out of their way to list two mechanisms of discovery and they intentionally leave out the others. The last thing, Judge Swinney, I'd like to follow too on what you point out, which I think is a really good issue that I don't think has come up before, which is, I think it's the Buckner v. Hassel case, which talked about that a treating physician, if they venture into standard of care, it does put them in the realm of Rule 26, and they do become a Rule 26 expert if they're going to talk about the standard of care. So you better believe, again, if we're going to apply this and say any Rule 26 expert is all of a sudden subject to all this, fishing for impeachment material.
Excuse me for interrupting.
Yes, sir.
That case that you just referenced, is it in your brief?
It is not. I don't think I don't think that issue was raised in the briefs by anybody, but since Judge Swinney brought it up, I thought I would address it.
That's fine. If you don't mind, just send a letter to the clerk with just the style of the case. Don't argue in the letter. Just say this is the case, reference an oral argument, copy your opponents, but again, just the name of the case and the site.
Yes, sir.
Don't argue it.
I understand. I understand. The only point I was going to make about that is that you're right. If a defendant physician, a defendant nurse, a defendant healthcare provider is going to talk about standard of care, I believe I complied with the standard of care. Mr. Powers gave an example of, well, yeah, but there's an attorney-client privilege there. That's one form of documentation. If we're all of a sudden we're going to open up the door to the defendant's handwritten work product, their notes, that talks about what their opinions are about their own compliance with the standard of care, because again, that's going to bring it squarely back within the work product doctrine, and they're going to argue that as a party, that they're entitled to assert that work product, and their handwritten notes or their thoughts and impressions, take the attorney completely out of it. So I think that the point is a very good one, that those things don't reconcile. They don't work together. Thank you.
All right. Court's thanks to counsel for both sides.
May I ask you a question, Your Honor?
Certainly.
May we also submit the case I thought of as Alessio?
Yes, was it not referenced in your brief?
Yes, I didn't know that she was going to come.
Oh, that's fine. Yes, please send a letter the same way. I'm sorry, I didn't think to ask if that one was in your brief, but yes, you may, of course.
I didn't think the name of it, so you couldn't have asked.
Don't worry, I can never remember the names of cases. My law clerks laugh at me. Recess or adjourn court until our next scheduled docket, please.
All rise. This court stands adjourned until Tuesday, November the 29th at 9:30 a.m.